You want your estate plan to work. You want every asset you own to move smoothly to the people you love. That starts with knowing what actually belongs inside a revocable living trust and what should stay out. Today, you learn the 5 categories that almost never go into a living trust, and the reason this single decision protects your money, your heirs, and the plan you are working hard to build. For 3 decades, Mr. Jackson has helped California families create living trust-based estate plans that avoid probate, maintain privacy, and bring real peace of mind. He has also spent thousands of hours in court litigating cases because people make bad legal decisions without understanding the consequences. He doesn't want to see this happen to you with your trust and assets. This video gives you clarity so you never end up on the wrong end of a legal decision. Let's begin with the first category. It's vehicles. Your everyday car or truck is almost always better left in your personal name and outside of your trust. These assets lose value every year, and retitling them creates a line of paperwork through the DMV, new insurance documents, and extra fees that provide little benefit. California already gives your heirs a simple way to transfer a vehicle after death with a statutory form. The only time a car belongs in a living trust is when you own rare collector-level automobiles with real value that you want protected and organized for your family. The second category of asset where ownership should not be transferred into your trust are retirement accounts. An IRA cannot be placed inside a living trust without turning the entire account into a taxable distribution. The IRS treats ownership changes of IRAs as a full cash-out, which means immediate income taxes on the entire balance. So keep IRAs in your personal name and update the beneficiary designation to your trust or the people you want to receive the account. This single step avoids probate without ever touching the ownership paperwork. The third category are 401k, retirement accounts. The same rule applies. A 401k is tied by law to an individual employee. Retitling it into a trust is treated as a withdrawal, which triggers taxes and sometimes penalties. You keep the account in your name and update the beneficiary form. That is how you protect the value, avoid probate, and keep your heirs out of court. The fourth category are annuities. These products should also not be transferred into your trust. Many annuity contracts treat a change of ownership as a taxable event. Some treat it as a full withdrawal. Some impose penalties for early movement. These rules depend on the specific contract and carrier, but the safest path for almost every family is simple. Keep the annuity in your name and update your beneficiary paperwork. This avoids probate and eliminates the tax complications that show up when ownership changes hands. The final category is life insurance. You can place a life insurance policy inside a revocable living trust, but doing so often increases your taxable estate. That is a real risk for families with significant coverage, because death benefits count toward estate tax calculations if you own the policy when you die. The better option is designating the trust as the beneficiary of the policy rather than transferring ownership. Families with large policies sometimes use an irrevocable life insurance trust, which keeps the benefit outside the taxable estate entirely. Your next step is updating every beneficiary form you own. Your IRA, 401k, annuity, life insurance, and even your health savings account need the correct designation. This is the engine that moves these assets directly to your heirs without probate. When you name your living trust as the beneficiary of a retirement account, make sure your trust includes the language the IRS requires, so the agency can look through the trust to the people receiving the money. This helps your beneficiaries avoid compressed payout periods under IRS rules, which can create unnecessary taxes. A properly drafted trust keeps your family on the longer distribution schedule the law allows. This is why a living trust works best when the right assets go in and the right assets stay out. When you combine the trust with correct titles, correct deeds, and correct beneficiary forms, you build a plan that protects your home, your privacy, and the future of the people you love. If you want help building a complete California Living Trust estate plan, you can use our do-it-yourself option and complete everything online in about 30 minutes. If you want expert guidance, personal review, and attorney oversight from Mr. Jackson or another lawyer from our office, take a look at our attorney-assisted Ultimate California Living Trust estate plan. Both options help you avoid probate, protect your family, and sleep better knowing this is handled. We've included the links in the description. Take a moment today and review your asset titles and your beneficiary forms. This single step gives your family clarity and keeps your plan strong during your incapacity or long after you're gone.